माननीय सुप्रीम कोर्ट में शिवसेना के नाम और चुनाव चिन्ह विवाद को लेकर एक बेहद महत्वपूर्ण सुनवाई हुई है। यह मामला सिर्फ एक राजनीतिक दल के भविष्य का नहीं, बल्कि हमारे देश के लोकतांत्रिक ढांचे और संविधान की गरिमा से जुड़ा है। माननीय मुख्य न्यायाधीश और माननीय जजों की विशेष पीठ ने इस सुनवाई के दौरान कुछ ऐसी तीखी और दूरगामी टिप्पणियां की हैं, जो आने वाले समय में देश की राजनीति की दिशा तय करेंगी। माननीय अदालत ने साफ शब्दों में कहा कि मूल राजनीतिक दल का नियंत्रण हमेशा उसके विधायक दल पर बना रहता है, चाहे विधायिका में किसी के पास कितना ही बड़ा बहुमत क्यों न हो। उद्धव गुट की ओर से वरिष्ठ वकील कपिल सिब्बल ने दलील दी कि अगर बागी विधायकों की अपात्रता पर फैसला पहले नहीं हुआ तो यह दल बदल विरोधी कानून का मजाक होगा। इस पर माननीय कोर्ट ने भी माना कि लोकतंत्र को अक्षुण्ण रखना हम सभी की सामूहिक जिम्मेदारी है। और आपको बताते चले, यह वीडियो पूरी तरह निष्पक्ष और केवल सूचनात्मक उद्देश्य के लिए है। हमारा मकसद माननीय कोर्ट की कार्यवाही, उसके आदेशों और न्यायपालिका का सर्वोच्च सम्मान करना है। हम माननीय न्यायालय का पूरा सम्मान करते हैं। तो चलिए बिना किसी देरी के सुनते हैं आज की सुनवाई की पूरी इनसाइड स्टोरी और समझते हैं माननीय जजों की उन टिप्पणियों का असल कानूनी मतलब।
This is now in the other matter.
Yes, now we are on the disqualification part. But that, yeah, the thing is over.
Correct.
Well, let me broadly, in 2 minutes, tell your lordships what my submissions are going to be, Well, the concept of a split is unknown to law, as far as the 10th schedule is concerned now. Split in the legislative party. So if that is not known to law, and if a disqualification petition is filed for violation of the 10th schedule, namely that you have voluntarily given up membership of the party, right? A defense can be taken that I am the party. That's the only defense available because 3 is gone, para 3 is gone, merger is not an issue. So the only defense available is that I am the party. So under the 10th schedule, the speaker is to decide whether the legislative members, whether it's 31 or 39, the party or not.
Party means I am the political party.
I am the principal party. Correct, Maras? That's already decided in Subhash Desai. That, you can't take a different view on that because Subhash Desai said it's the political party is SHIVSENA Uddhav. They are entitled to issue a whip. They are entitled to direct as to who is going to be the leader of the party in parliament. So all that is already decided in SHIVSENA. What the speaker does, and I'll tell you, lordships, in about a minute or so. What the speaker does is he says, yes, I agree, I have to decide this matter, but, and also agree that the 2018 constitution is relied upon on both sides. But now I have to decide as to whether the 2018 constitution's power structure, party leadership is consistent with the 1999 constitution. So I find that it is not consistent with the 1999 constitution. And because it is inconsistent, I disregard the power structure. And therefore, I'm only left with the legislative party. And the legislative party is the political party. Now, how can the speaker even look at the constitution when this court in Subhash Desai has already decided?
This order by the speaker is post Subhash Desai.
Yes.
Post Subhash Desai.
But as I tell your lordships, and this is a side of this, the problem arises, and your lordships can clarify it. Assuming, a party can go to the election commission and claim that it is the party, and those legislators are the subject matter of a notice for disqualification, while the election commission is free to decide as to who is the party, that decision should only happen when the disqualification is decided, because then you will determine as to who are the members of the party. Supposing they are disqualified, the legislature will be disregarded. So therefore, even though Subhash Desai may be right on the issue that let it go to the election commission, the process of determining who is the party must be consequential upon the decision of the disqualification petition. That's my submission, and your lordships can clarify that, because otherwise this problem will arise every time. Because we disqualified at the initial stage is 16.
Yes. Then 22.
Then 22.
Yes. In tranches.
That's right. 16, 22.
Then 39.
Then 39. Then 39. So 21A and 21B. So that's how the Speaker Malas has dealt with the issue, and how the Speaker.
That is the domino effect taking place.
That's right. That's correct. And how the Speaker can look at constitutional Malas under the 10th schedule, was a bit difficult for me to appreciate. Anyway, now Malas, I'll quickly take your lordships through this. Won't take much time, Malas. First paragraph of my submissions.
Very short issue.
Very short issue, Malas.
This is an issue only.
Impact of the decision is no longer relevant.
Yes,
It may be relevant as an collateral
that's
issue for the symbolic.
right. Absolutely right, Malas. Because we can't do
Because
anything.
now,
Disqualification is irrelevant.
does not make any.
Correct. But you can still upturn the verdict, Malas. If that happens, then the whole concept, Malas, of legislative majority doesn't arise at all. Then I am the majority even in the legislature. That's why I suggested a way out, Malas, of this conundrum. Namely, even if the election commission were to take a decision, it must await the disqualification petitions. Otherwise,
That Subhash Desai did not.
no, it doesn't. I am not. No. I'm not on that. I'm not saying, Malas. Subhash Desai did not say. I said stay the proceedings. Subhash Desai said no. So, Malas, I'm not on that. Don't stay the proceedings.
Desai's ratio was the parameters are different.
That's right.
Those paragraphs.
That's correct. So that's fine. I'm not saying stay the proceedings. I'm saying you will only be able to determine as to who comprises the party, which includes the legislative wing of the party, once the disqualification is decided. Otherwise, you file a disqualification, he goes to the election commission, gets an order, disqualification is not decided in several years, new election takes place, and we're landed with this. So that's not workable, is what I'm saying, Malas. So you could clarify it, Malas, without any sort of impact on what Subhash Desai has decided. Anyway, Malas, I'll quickly, Malas, go through this. Now, Malas, the petitioner filed disqualification petition number so-and-so on 23/6/2022 against 16 MLAs under paragraph 21A. Disqualification petition number 18 of 2022 against 22 MLAs on 27/6/2022 under paragraph 21A. Disqualification petition number 19 of 2022 on 3rd of July against 39 MLAs under paragraph 21B for violation of whip relating to Speaker's election, and disqualification petition number 21 of 2022 on 5/7/22 under 21B against 39 MLAs for violation of whip relating to confidence motion. All petitions came to be dismissed by the Speaker by 4 impugned judgments dated 10/1/2024. Now, Malas, what I'm going to do is I'm going to place before your lordships facts that are not controverted. So we go on admitted facts. So there can be no dispute on that. Now, Malas, determination that the respondent group, on account of their majority in the legislative wing, represents the SHIVSENA political party itself. Consequently, the whip and leader appointed by
the strength of the house. What was the strength of your party?
55.
In the house.
In the house, 55.
More than 50.
50 cents of SHIVSENA, Malas.
SHIVSENA was 55.
55.
They were 39.
And you were
They were 39.
39.
Initially 31, then 8 joined later.
More joined.
They were 39. So, Malas, determination that the respondent group, on account of their majority in the legislative wing, represents the SHIVSENA political party itself. Consequently, the whip and leader appointed by resolution dated 21/6 is the validly appointed whip and leader. Malas, now kindly see this at page 578, 658 in the convenience compilation. Okay, I'll show it later. My learned friend says I should read out the whole thing.
This is 2 marks.
Okay.
In the next one, we've broken it down.
All right, I'll do that. Okay, now we go back how?
Go back, go back. Just
Okay, all right. Then B, determination that respondents' actions from 21/6/22 onwards do not amount to voluntarily giving up membership of the SHIVSENA political party under paragraph 21A. That's the second finding of the speaker. 3, determination that respondents' actions in relation to voting in speaker's election on 3/7/2022 and in the confidence motion on 4/7/2022 did not amount to disqualification under 21B. So these are the 4 conclusions that he has arrived at. It is respectfully submitted that each of the above aspects, the impugned judgment, are legally and factually untenable. Then paragraph 4. In the impugned judgment, the speaker, honorable speaker, has completely exceeded his jurisdiction under the 10th schedule and disregarded the SHIVSENA political party leadership through an exercise that is contrary to the scheme and structure of the 10th schedule. Thereafter, on account of the number of respondent MLAs amongst the legislature party, the speaker has held that the majority legislators represent the political party itself. You want me to show them? Now kindly see paragraph, page 632 to 633 of the convenience compilation. Right, this is it. Page 632 of the convenience compilation, paragraph 129.
Is there a separate convenience compilation for it?
Same.
Same.
Summarizes his findings.
Well, it's 129 summarizes his findings that I have already read. So, your lordships may not read 129 because I've already summarized the findings. Okay. Okay. Thus, I'm sorry, 129. I didn't keep intervening. I was reading it. Thus, the paragraphs 112 to 128 have dealt with whether the relevant leadership structure read with the SS Constitution, SHIVSENA Constitution, provides answer to the question, which faction is the real political party? In view of the same, I record my conclusions and findings thereon as under. 2018 leadership structure is not at all in conformity with the constitution of the SHIVSENA and thus does not provide a reliable outcome and or answer to the question, which faction is the real political party, and hence cannot be relied upon to determine the preliminary issue. So which constitution is he talking about? Under what provision of the 10th schedule is he talking about? Decision of the Paksh Pramukh is not synonymous with the will of the political party. And thus, if there is a rift in the leadership structure, the decision of the Paksh Pramukh cannot be taken as the will of the political party. How does he say that? Admittedly, I am the Paksh Pramukh. Uddhav is the Paksh Pramukh. Admittedly, I appointed him. Admittedly, he fought an election under my leadership. Admittedly, he got a symbol under my leadership. And he says that he need not be recognized. When there is a vertical rift in the horizontal leadership hierarchy of the political party, and both the factions within the said leadership structure emerged as a result, claim to represent the will of the political party, it would not be appropriate to apply the test of which of the said factions' decision carries the will and wish of the political party. Not only is it against Subhash Desai, it is against all principles of law, Malas. Admittedly, the legislative party is not the political party. So he can't assume that a rift in the legislative party represents a rift in the political party. It's already decided in Subhash Desai, Malas, that you can't conflate the two. Then he says, in the case of the SHIVSENA political party, quote, will of the majority leaders in the 2018 leadership structure cannot be said to be synonymous with the will of political party. What does this mean?
Even if majority leaders are agreeing, it doesn't matter.
It doesn't matter, Malad. Supposing I had majority and the minority had committed this, it would still be my will. There is no principle of law in which you can consider the legislative party to be the political party. In view of the finding recorded in the preceding paragraph 1, I hold that the 2018 leadership structure, read with this, I've read it, Constitution, does not provide any reliable answer to the question which faction is the real political party, and consequently the 2018 leadership structure cannot be the yardstick to determine which faction is the political party. After having come to the conclusion that neither the test of Constitution nor the 2018 leadership structure can be made yardsticks to determine which faction is the real political party, I have now to proceed to determine whether legislative majority can provide answer to the question which faction is the real political party, and consequently which faction is the real political party accordingly. Then Malatsi says at 132, as recorded earlier in paragraph 84 herein, the Honorable Supreme Court in Subhash Desai has held that the question of who the real political party is has to be considered and determined after giving due weightage to the SS Constitution, the leadership structure of the party, legislative majority if two of factions claim to be the real party. Having arrived at the conclusion that the 2018 leadership structure read with the relevant constitution of the SHIVSENA does not provide a reliable outcome to settle the issue of which faction is the real political party, I now turn to the test or mechanism that exists based on the legislative majority. It is well settled position of law that where the question arises as to which group is the party, strength of the group becomes an important and relevant factor. It is obvious why the legislative party majority becomes a relevant criteria to be taken into account. And he relies upon Sadiq Ali, Malad.
Quotation is from Sadiq Ali.
This quotation is from Sadiq Ali. When Sadiq Ali was a para 15, Malad, it was between political parties, the two factions of a political party. As I told your lordships, he knew what he had to decide. Then he sort of, through some convoluted logic, tried to reach that particular outcome. Then was 133, and then I'll go back to. For the purpose of determining which faction enjoys the legislative majority and considering that the present preliminary issue has to be determined prima facie, I have to only look into whether majority in the legislative party can be discerned or inferred from the office records of the Legislative Secretariat. No other documents can be taken into account at this point in time, and I have to only consider documents or materials which were on record of the Legislature Secretariat will be. Now he relies upon, and when their speaker decided against us, he recognized their whip. This is Gangavale, which also the Supreme Court in Subhash Desai said cannot be done.
Again recognizes it.
He again recognized. So it is contrary to the findings of this court. Now, Malas, I have dealt with these conclusions. Now I come to now Malas kindly. And thereafter, come back to my paragraph 4 minutes. I come to 632, 633. Through an exercise that is contrary to the scheme and structure of the 10th schedule. Thereafter, on account of the number of respondent MLAs amongst the legislative party, the speaker has held that the majority legislators represent the political party itself. Then, the reasoning of the speaker is in the following parts. It is first determined that the SHIVSENA party constitution that is required to be looked at for the purpose of identifying the SHIVSENA political party leadership is the 1999 constitution, since that is the constitution available on the record of the Election Commission. In other words, where does the speaker get the jurisdiction to get into all this? This he says at page, in the convenience compilation, page 598 to 602. Kindly have a look at that.
Para 96.
Para 96.
598.
Yes, 590, para 96. All right. MLS, actually, he relies upon two paragraphs of the Subhash Desai judgment, and I must be fair to your lordships, Millers, to point out those paragraphs, which is paragraph 174 and 175 of Subhash Desai. If your lordships don't mind, Millers, I'll go that at first and then come back here. That your lordships will find in the judgment compilation, main judgment compilation, Millers, page 91. Yes, paragraph 174, 175. I can say with some candor, Mother, that this was not neither argued by us nor by them, nor is it part of any of our submissions, but this is what the court said. Regardless of my, sorry, Mother, your lordship had that? Page 91 of the judgment compilation. My Lord Justice Bakshi had it? My Lord the Chief Justice
Yes, sir.
says, regardless,
Defense available.
yes, regardless of the defense available to members who face disqualification proceedings, the speaker may be called upon to determine who the real political party is while adjudicating disqualification petitions under 2(1)(a), where two or more factions of the political or legislative party have arisen. The effect of the deletion of para 3 is that both factions cannot be considered to constitute the original political party. In order to determine which, if any, of the members of the party are voluntarily giving up membership of the political party under 2(1)(a), it is necessary to first determine which of the factions constitute the political party. This determination is prima facie determination that will not impact any other proceedings, including proceedings under paragraph 15. Now, that determination has already been done in Subhash Desai, Millers. That's my humble submission. Now come to Millers 175, which is the problem. In arriving at their decision, the speaker must consider the constitution of the party as well as any other rules and regulations which specify the structure of the leadership of the party, if the rival groups submit two or more versions of the party constitution. The speaker must consider the version which was submitted to the ECI before the rival factions emerged. This is important. Now, there were no two rival factions, rival versions of the constitution. There were none. Admittedly, Millers, there were no rival factions. 2018 was relied upon, and the court said this is very important. In other words, speaker must consider the version of the party constitution which was submitted to the ECI with the consent of both factions. That's the 2018 constitution. And then it further says in the previous sentence, if the rival groups to submit two or more versions of the party constitution, speaker must consider the version which was submitted to the ECI before the rival factions emerged. They did not submit. They never make an argument in this court, Mother, that there is a 1999 constitution. Nobody made an argument. In the final submissions before the speaker, they made that argument because it was convenient. And they relied upon this paragraph, which the speaker relies upon, when we know that there were no two versions of the constitution that were submitted by either party. They relied upon the 2018 power structure and acted on it. When I show you the correspondence, he says, I don't recognize you as a whip. I decide that the whip is Gagavale. Under which constitution was he deciding? 2018? There is no Paksh Pramukh into 1999. The speaker knows it. The election commission knows it. This will obviate a situation where both factions attempt to amend the constitution to serve their own ends. That's the issue. Whereas if there is a constitution, they seek to amend the constitution, and there are two versions that are placed before the speaker, I can understand that situation.
It's before the ECI.
Before the ECI. Even that didn't happen. So how this paragraph came in, Malad, at least we never argued it. Further, the speaker must not base their decision as to which group constitutes the political party on a blind appreciation of which group possesses a majority in the Legislative Assembly. This is what exactly he has done. He says, this is not a game of numbers, but of something more. The structure of the party leadership outside the Legislative Assembly is a consideration which is relevant to the determining of the issue. And he discards that.
The speaker goes only by the legislature, not outside.
So, Malad, I just wanted to point that out. But this is the basis on which the speaker, relying on this paragraph, says, I will not look. Close it? Okay, now come back, Malad, to my submissions. Para 5. It is first determined, sorry.
Quote of para 175.
I have no idea. I have really no idea. I've been racking my brain, Malad, ever since. I can't find an answer.
Goes this way and there.
No, Malad, I tell you, Lordship, honestly what I think. By that time, the Election Commission's decision had come.
When the judgment was ready.
Like two divided groups.
Honestly.
Paragraph, like two divided groups.
Yes.
This paragraph is also divided.
Well, this is my thing. My thinking. The court, the bench knew that there is an Election Commission decision, and they incorporated something here. But they, anyway, I mean, the decision doesn't help them in any case. Yeah.
See that the bench speaks of proceedings under paragraph 15 of the symbols order,
Yeah.
contemplating thereby that the proceedings had not come to culminated in a
That's
finding.
right. That's right. It hadn't. No.
Just said that the symbols order had come.
They had passed that order. But SNP was pending.
Particular day.
SNP was pending. It had not culminated. I mean, it had culminated at the level of the Election Commission, but not otherwise. That's how we are here, Malad. Para 165, Malad, of Subhash Desai, the court says
165.
165. We'll just take that, Your Lordship. Para 165. Page 88, Malad, of Subhash Desai.
Ordered the symbol.
Para 165, page 88. Yes.
In the proceeding.
Yes. I'll read it, Malad, after your Lordship. It says, in the proceedings instituted by Shri Shinde, under para 15 of the symbols order, the ECI awarded the symbol bow and arrow reserved for the SHIVSENA to the faction led by him. The petitioners challenged this order before the
Paragraph, the word proceedings in 174 relates to the proceedings as in the special leave petition examining the correctness of the symbols.
That's correct.
That will not be impacted by whatever decision.
That's correct. That's correct.
That he clarifies, including the proceedings.
Yes, it says. It says. We have not expressed any opinion on the merits of that case. So, Malad, he lifted that finding of the commission, but in any case, even para 174, 175 doesn't deal with it, Malad. So, going back to my submissions, para 5 at page 2, Malas. It is first determined that SHIVSENA party constitution that is required to be looked at for the purposes of identifying the SHIVSENA political party leadership is the 1999 constitution, since that is the constitution available on the record of the commission. Malas, how is the speaker concerned with this? If you say that those proceedings are separate, this is separate, then how do you bring in what the election commission has decided? Supposing the election commission's decision is overturned? That's why I said, Malas.
Mr. Sibal, 2018 was relied by both parties. But after the chief whip was appointed by the Shinde faction, they also amended the constitution by making himself, or they appointed.
Or this very constitution, 2018.
They created a post.
That's right.
I think some Pradhan.
Mukhya Neta.
Mukhya Neta. So the Mukhya Neta decision, was it communicated to the election commission? No, there is no such evidence.
There is no such. But even if it were, Malas, it may.
No, we're just asking.
No, not that we know, Malas. It's not on the record.
Simple, we could have given some meaning to the first lines of 174, that there are two rival amendments, and therefore which rival amendment is with the election commission will be taken into consideration.
But even then, it couldn't have taken him back to 1999. That's the point.
We are saying that can give some explanation to 174 lines.
Those amendments anyway are 26 July.
And those amendments are 26th of July, Malas.
Not
21st of June.
when this disqualification.
This qualification happens on 21st of June. That's the other problem
We are trying to find out a reason.
for 174. I understand.
Not the correctness of
I
or the reliability of the amendment.
I understand. Appreciate that. It is first determined that SHIVSENA party that is required to be looked at. Anyways, B. Thereafter, it is determined that the SHIVSENA political party leadership is as reflected in the letter dated 27/2/2018, available with the website on the website of the Election Commission of India.
This is my leadership.
Kindly see this at page convenience compilation 604 to 606.
Should be searched.
Yes. I'm showing that. Para 100, Malas. This is paragraph 100. Have Lordship had it?
8604.
Page 604. After having considered the submissions advanced by both the parties on the question as to which is the relevant leadership structure, for the purpose of determination of the preliminary issue, I have come to the following conclusions. The submission of Mr. Kamath that, quote, the jurisdiction under the 10th schedule only mandates a prima facie adjudication as to what is the leadership structure of the political party, was at the relevant time. And it does not extend to any inquiry as to whether or not the leadership structure available on the record of the Election Commission of India was pursuant to a validly held election, is a correct proposition, and hence I concur with the same. So he agrees that this is the leadership structure, yet he discards it. Petitioner's submission that, quote, in these proceedings, the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct proposition, and I am in agreement with the same. Your Lordships will remember under 29A, 9 Malas, whenever there was a change in the office bearers, we forwarded to the commission. So he says that's fine.
Whether that is in accordance with 99.
Whether that is in accordance with the 99 Constitution, he discards everything. Respondent submission that the said leadership structure of 2018 cannot be considered and relied upon for the purposes of determining the preliminary issue as the said leadership structure is not in conformity with the constitution of the SHIVSENA, which is in record of ECI, does not arise at this juncture. What does that mean? And it is a submission which has to be considered by determining whether the said leadership structure can be relied upon for the purposes of determining which faction represents the real political party, which would be dealt with at the appropriate juncture.
29.
That's the 129 that I mentioned. The only question which is to be determined in the current part of the order is what and who all constituted the leadership structure of SHIVSENA at the relevant time. Then let's kindly come back. No need to read. 101, your lordships may read. Yes. 101, 606 page. Thus, in view of the above conclusions, I find that the leadership structure of the SHIVSENA reflected in the letter of 27th February 2018, available on the website of the ECI, is the relevant leadership structure, which has to be taken into account for the purpose of determining which faction is the real political party. This is me, Malad, as Paksh Pramukh.
Even supports me in something. Majority support.
The question whether which faction is the real party is discernible from the 2018 leadership structure is discussed in paragraphs 112 to 131. So, Malad, he accepts the fact that the leadership structure is as reflected in the 2018 Constitution and as informed, as was informed to the Election Commission on 27th of February. So how does 99 Constitution come in at all? Because it's not in the record of the Commission. So let's go back to C, para C, Malaz. Then, Malaz, sorry. Para C of my submissions. Then the Honorable Speaker, completely without jurisdiction, proceeds to compare the political party leadership with the 1999 party constitution and concludes that the political party's leadership structure is not in accordance with the party constitution and consequently discarded the representative of the SHIVSENA political party. Now, how is this part of the jurisdiction of the 10th schedule? Once he recognized that I am the political party, the structure is this, I am the Paksh Pramukh, he doesn't disagree with that, he is appointed under that, then where's the question of going back to the 1999 Constitution? This is not some academic exercise, Maharaj, that's going on. It's real politics. I mean, I give him the symbol. He fights an election on that symbol. He becomes a minister on that symbol. And then the speaker says, no. But you are not, I can't recognize you even. But Malad, if he can't be recognized, that he should be effaced, Malad, he should not get this order at all. If everything that was done was under the 2018 Constitution, he can't get the benefit of that Constitution then. He was elected under that. So you discard this Constitution, given the benefit, give one faction the benefit. And then he says, because of the legislative majority, he's the political party. This befuddles me, Malad, befuddles logic. Then, Malad, kindly come to D. The speaker completely overlooks the fact that the SHIVSENA legislatures were set up for elections by the very same party leadership, and that under the 10th schedule, the legislatures are bound by the directions of their political party leadership. On an appreciation of the relevant majority amongst the legislators, the speaker holds the respondent MLAs represent the real SHIVSENA political party. So now it's clear, Malad, he says the MLAs represent the political party. This can't be done, Malad, under the 10th schedule. And contrary to Subhash.
He is using the Sadiq Ali test.
Sorry?
Sadiq Ali test.
Yes.
Applying the Sadiq Ali.
Exactly.
If there is no clarity as to majority in the political party, we fall back on the legislative majority as a reflection of.
Sadiq Ali doesn't say that, Malad.
That is what
You said look at both.
yes, look at everything.
Yes.
But if there is lack of clarity, then we have to come to a decision.
It's in
So
that-
what we come to a decision
Right.
is more
Yes.
a guesstimation
Yes.
in view of the
Absolutely.
picture in the
Absolutely. Absolutely right. But
Sadiq Ali is decided prior to the amendment.
prior to the 10th schedule. But apart from that, Mullah, what Sadiq Ali says is we.
Sadiq has to be understood. When you apply Sadiq Ali ratio, split is recognized as a valid part of the same political.
Yes, you're right.
So that has to be also taken.
But that split even recognized allows them as a defense not to be disqualified.
Why?
That's right.
Because if you have a majority in the in the legislative party, the scheme of 10th schedule as it stood then was considered to be the aspiration of the political party.
Correct.
After the amendment, this defense does not exist. Now, whether the ratio of Sadiq Ali will hold has to be seen.
In my
Post
turn, I'm going to address that post, my lord, the introduction of the 10th schedule and the deletion of paragraph 3, in our respectful submission, my lord, that legislative majority test and split will have to be relooked at, my lord, because you are promoting something which the constitution abhors. So that's, my lord, my submission I'll make. That.
Until and unless there is a merger.
Yes, until
Right.
there is a merger.
But let's look at Sadiq Ali. Look, Sadiq Ali, para 3 proceeds with the assumption that there is a split in the political party. Para 3 doesn't talk about split in the legislative party. Para 3 proceeds on the assumption, and that's Uttar Pradesh case, Mullah. Rana. You proceed on the assumption there is a split in the political party, then the question arises. In Sadiq Ali, they said, when we look at the organization structure, it is so divided that we can't determine which faction. So that was in that context. But in terms of paragraph 3, you still have to show there's a split in the political party.
That this is how the speaker brings in Sadiq Ali ratio.
Yes.
By saying in Sadiq Ali, factually, they were not able to
That's right.
find out
Right.
what was the organizational strength. Why? Because no elections were held.
That's correct.
You see
Your
the
Lordship is
difference.
right. Your Lordship is right.
There was no dispute about constitution.
No.
Here what they said,
They were competing claims, but not that no elections were held. They were competing claims in the organizational structure.
finding was there was no election held as per the constitution.
No, my lord. In fact, in Sadiq Ali, my lord, just to give the facts, the Supreme Court, my lord, categorically says that it is not a case where, my lords, one faction says they have legislative majority and the other faction says we have legislative majority. So organizational majority. So it was a case, my lord, that where one faction had both legislative and organizational majority, and the court said it can be a relevant factor. And the court says we are not laying down the law that in a case where there is a complete divergence between one faction enjoying the legislative majority. Yes, no, so
we are aware of that.
Yes,
The
para 26.
issue in Sadiq Ali was more relevant is why they were going to the legislative majority
Yeah.
when the question was to see the the party majority.
Yes.
Because the facts were not clear as to what was the majority in the party. So they fell back on the legislative majority
In fact,
as a convenient tool.
Well, let's for a moment accept that, Malad.
both were looked.
No. My Lord is saying something else.
Sadiq Ali.
Yeah, they looked.
Organization was
Yeah. He's not. My Lord is not saying that he wasn't looked at. Point out.
Organization majority was there, sir.
Uh,
And legislative majority was also there in Congress.
yes.
And therefore they said that this faction seems to have the.
Yes. You're right.
This was not a case that there is
Uh.
some kind of a problem like organization majority.
Yeah.
In fact, it makes it very clear in paragraph.
दे दो paragraph 30.
16.
Well, that's The Congress was majority.
Majority.
Both. Yes, yes. You deal with it. No, you can show it. In Sadiq Ali, Congress so. Yes,
Right.
and Congress
It
had majority
Congress-
in.
Congress versus Congress.
Yes, and Congress who had a majority in the organizational wing as well as legislative. So they looked at both, but this exercise that he has done.
He looked at both and they said that the organization is so disorganized, it is very difficult to
No.
rely on it.
Para 30 doesn't say that. That's, I'm just,
Let us see.
we
That
stand
is what they
corrected.
say.
Para 25.
Para 25 of Sadiq Ali.
Page
343, Malas.
Page
343 in the judgment compilation that we've given, same
Yes.
judgment compilation. Final. So put it.
Circa mark.
Kindly see, I'll show your lordships now, Madam. 25, paragraph 25. Let me show you.
In the supplementary.
No. Final compilation. Main compilation.
Okay.
Yes, same one that has Subhash Desai, correct.
What must?
Submissions, Mullahs. Para 13, Mullahs. Small, Mullahs, the thin paper portion. Thin one, Mullahs.
232.
Yes, that's the one. My submissions, yes. Filed on 13th of August. And what has it? This is page 5, Mullahs. Submission 13. Therefore, the Election Commission allots the symbol of a recognized party to a candidate only on the basis of the prescribed communication by the political party's leadership as available on the records of the Election Commission of India. Consequently, the original political party of a legislator that sets him up as a candidate is necessarily to be represented by the political party's leadership for the purposes of the 10th schedule. And I've shown your lordships Form B and all that, as well as paragraph 1 explanation B, B explanation to the 10th schedule. Then as per para 6 of the 10th schedule, the only question to be determined by the speaker in proceedings for disqualification is whether a member of a house has become subject to disqualification under this schedule. There is no other inquiry to be made. Therefore, by entertaining a plea that the political party's leadership is not in accordance with the party constitution and consequently not representative of the political party is wholly beyond the scope of the 10th schedule. To hold otherwise would allow delinquent legislators, see the mischief, Mullahs, to dispute their political party's leadership after having relied on it to get elected to the House. Such an interpretation is totally contrary to the scheme and structure of the 10th schedule. Then, Mullahs, anybody, any breakaway faction or in the legislature can say, I don't accept you as the leader. As they said, I don't accept you as the leader. I will make myself as the Mukhya Neta and I will have my own whip. I don't accept you. That's not contemplated on the 10th schedule, especially when you got the benefit of the very party under which you were elected. So in Subhash Desai, I just want to point out para 119 of Subhash Desai. Whereas I've already quoted it here, if I may read from here instead of taking your lordships through the judge, no point, Mullahs. To hold that it is the legislative party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators could rely on the political party for the purposes of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. But this is very important. In fact, the 10th schedule guards against precisely this outcome. The whole purpose of the 10th schedule to ensure that the sin of defection is nipped in the bud. You will now give it mullahs, mushroom it, allow it to mushroom mullahs if this kind of interpretation is given. And mullahs, now this actually determines the issue. How the speaker can go contrary to it, mullahs, we don't understand. And this is page 76 of the judgment compilation. Then, mullahs, number 2, the legislature party can never be treated as the political party itself under the 10th schedule. The 10th schedule provides for disqualification of legislators from being a member.
Just for the information of the members of the bar, no other matter will be taken up. It's a part of the matter, it's continuing. So the rest of the board is discharged.
The 10th schedule provides for disqualification of legislators from being a member of the House when they have conducted themselves in a manner that amounts to voluntarily giving up membership of their political party, or when they vote contrary to the directions issued by their political party. The term legislature party finds mention in the 10th schedule only at 2 places. I've already quoted that, 1B, mullahs. I won't read that again. Defines legislative party. Para 4, which deals with defense of merger, that the relevance of a legislature party under the 10th schedule is only at the time when the defense of merger is set up. That's not the case here. It is pertinent to state that the term legislature party also finds place in the erstwhile para 3, which provided for the defense of split. Now, my contention is in the absence of a split, there is no defense available to them. On the 21st of June, there is no defense available to them because split is not accepted. If you allow this to happen, you will bring back split through the back door and say this is a defense available. So the only defense they could have had was that I am the political party. That's what was decided against them. They can't in any case, because on 21st of June, they never claimed to be the political party, except to the extent they say, we are majority of the legislators, therefore we are the political party. Well, that's not available to them. Thus, a group of legislators, howsoever large in number, is bound to follow the directions of its political party, else they will be subject to disqualification, barring the limited exception of merger. The distinction between the political party and the legislature party and the limited relevance of legislature party in the context of the 10th schedule was noticed by Subhash Desai. Political party, para 109, cannot, I've read it, mullahs, cannot be conflated. That's the paragraph already read before your lordships. Contention of the respondents that political party and legislative party is inextricably intertwined is erroneous for the following reasons. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislators. It was with this objective that the defenses of merger and split, which was later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislatures, which would otherwise lead to disqualification if a substantial number of legislators, 2/3 in the case of murder and 1/3 in case of erstwhile provision of a split, disagree with the political party. The next is important. The 10th schedule recognizes the independent existence of the legislature party to the limited extent of presenting a defense to the actions of the legislature, which would otherwise have amounted to defection. And that defense in this case is not available because that defense is only a para 4 defense, which is a merger defense, given the page of the judgment. It is pertinent to state that a political party is a permanent body registered with the Election Commission in terms of 29A. It may or may not contest elections, or even when it contests, it may not return any successful candidates. On the other hand, a legislative party is merely the group of legislators who at a particular time comprise the successful candidates belonging to the political party. Thus, by its very nature, a legislature party is temporary and its existence is coterminous with the term of that house. It has no existence beyond the term of that house, Mullahs. Whereas a political party registered has an existence, Mullahs, much beyond, Mullahs, the elections. So that's another, Mullahs, inherent distinction between the legislature party and the political party. If a majority group of legislators are held to represent the political party itself, the actual permanent organization outside the house would lose all significance. It would just lose significance, Mullahs. And the legislators would get a free hand to defy their political party for extraneous considerations. This is the sin, Mullahs, that needs to be nipped in the bud. This would place the political party and its workers and supporters at the mercy of the machinations of opportunistic legislators, an outcome that the 10th schedule is designed to prevent and punish. The Honorable Speaker in the impugned judgment has treated the majority group of the legislators as the SHIVSENA political party itself, and thereby upended the structure of the 10th schedule. Now, let's come to the 2018 party leadership. Mullahs, the irony is you base your legitimacy on an illegitimate act. And that illegitimacy continues for years. And then you will ultimately say to the court, now that it has continued for years, give me legitimacy. It's like, Mullahs, an unauthorized construction on government land. You construct, the government does nothing about it. Then at some point in time says, this is government land. You say, but I have been there for a long time. So this Mullahs, unauthorized construction of the 10th schedule can't ever, Mullahs, be to their benefit. It is submitted that the SHIVSENA political party leadership was duly reflected in the letter dated 27th of February, submitted before the Election Commission of India. Shri Uddhav Thackeray, as the Paksh Pramukh, was elected leader of the party. Further, Shri Uddhav Thackeray enjoyed overwhelming support in the party leadership. This was duly demonstrated before the Honorable Speaker through affidavits of support sworn by 9 out of 13 leaders and 24 out of 33 deputy leaders. Mullahs, your lordships may have a quick look at this document, Mullahs. This is at page 21 of the compilation, Mullahs, the convenience compile, final convenience compile. That's the
21 letter of 27.
Yes, I'm reading. Yes. Show me that. Where is it? Yes. Page 21, Mullahs. Yes.
Shown in the beginning also.
That's right. That's right. I just want Mullahs to refresh. Organizational elections been conducted on 23rd January at Mumbai, and the information regarding designation, that's in terms of 29A. So I'm sorry, Mullahs, I go back to my submissions. And then, Mullahs, and then at page 170 to 187 and 188 to 235, we, Mullahs, inform the commission that this is the support enjoyed by us. On the other hand, the respondents group neither pleaded nor produced, this is important, nor produced any material before the Honorable Speaker to demonstrate the support enjoyed by Eknath Shinde amongst the political party leadership. Now, Mullahs, I'm talking about 19th of July. But that's the time when he had to, Mullahs, demonstrate that support. Para 27. Therefore, the Honorable Speaker was bound to recognize Uddhav Thackeray in his capacity as Paksh Pramukh to be representative of the SHIVSENA political party. In Subhash Desai, the Constitution Bench duly acknowledged the communications actions of Uddhav Thackeray in his capacity as Paksh Moksh to be representative of the Shiv Sena political party. That's para 128, I'll just read it. On 21/6, that's the letter I just showed you, there was no material on record before the Deputy Speaker for him to doubt the resolution of the Shiv Sena Legislative Party dated 21/6, appointing Ajay Chaudhary as the leader of the party. It was dehorsed the political party, or that two factions of the party had emerged. The resolution was signed by Mr. Thackeray in his capacity as party president, much like the resolution appointing the whip and leader in 2019. This makes it evident that Mr. Thackeray issued the communication on behalf of the political party. Thus, the decision of the Deputy Speaker recognizing Ajay Chaudhary as the whip and in place of Eknath Shinde is valid. This is what he says. Even otherwise, it is respectfully submitted that the entire exercise of requesting the Election Commission to provide a copy of the party constitution, which has been submitted to the Commission to hold that the 1999 election constitution is the relevant constitution of Shiv Sena, is completely unlawful without jurisdiction. The details of the communication with the Election Commission are recorded in the impugned judgment as follows. As I'll read this. He says, as per the Honorable Apex Court, if both the factions have submitted different versions of the constitution of the party, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before the rival factions emerged. Before recording further conclusions, I find it imperative to reiterate that pursuant to the initiation of these disqualifications, the Maharashtra Legislative Party had, by letter dated 7th June 23, requested the Office of the Election Commission of India to provide a copy of the party constitution, memorandum, rules, whether known as such or by any other name, of Shiv Sena political party, which have been submitted to the Election Commission of India and stand effective as on 21st of June. It is also pertinent to mention that in the said letter, it was specifically requested to the Election Commission of India that copies of all subsequent amendments, if any, to the Constitution be also provided. In response to the said letter, the Election Commission, by letter dated 22nd June, provided a copy of the Constitution and rules of Shiv Sena as available on the records of the Commission. Further, with respect to amendments, if any, to the said Constitution, the Election Commission requested the Legislature Secretariat to refer to the order of 17th February passed by the ECI, case number.
This is the symbols order.
This is the symbols order, Malaj. Where Election Commission recognizes both sides, Malaj. And they say they have relied on this to 2018 Constitution. It is respectfully submitted that in the present case, there was no occasion to consider the Constitution submitted to the Election Commission, since both parties had relied on the same version of the party Constitution, being the 2018 Constitution, which was appended as Annexure 18. Malaj, they appended it in their reply. And then before the Speaker, Malaj, they appended this very Constitution. And then at a later point in time, filing an additional affidavit, they say this was by mistake. This is a lawyer's mistake. Having appended the Constitution.
39 separate replies.
And they filed 39 separate replies, Malaj. This in 2018, because each was separate, Malaj. So each of them mentioned the 2018, provided the 2018 Constitution. So 13 advocates, Malaj, made a mistake. 39 advocates made a mistake. That may also be a conspiracy, Malaj, to make a mistake together. It is respectfully submitted that in the present case, there was no occasion. No, I've read that. Then let's kindly see item 4, para 30. In Subhash Desai, the Honorable Constitution Bench has duly considered the legality of the rival resolutions dated 21/6, one by the political party leadership replacing Eknath Shinde with Ajay Chaudhary as group leader, and the other by respondent MLAs reaffirming Eknath Shinde as group leader, and replacing Sunil Prabhu with Bharat Gogavale as Chief Whip. Both resolutions were specifically before the Honorable Constitution Bench in the writ petition that was decided. So once the Constitution Bench has rendered a decision, how can the Speaker decide contrary to it? After considering the issues, the Honorable Constitution Bench held the Honorable Deputy Speaker's decision that dated 21st June, accepting the resolution communicated by Uddhav Thackeray to be valid. On the other hand, the Speaker's decision on 3-7, accepting the Shinde's group resolution, was held to be invalid. However, the resolution passed by SSLP on 22nd of June brought to the attention of the Speaker that it was passed by a faction of the SSLP. Thus, the Speaker, by recognizing the action of a faction of the SSLP, without determining whether they represented the will of the political party, acted contrary to the provisions of the 10th schedule, the 1986 rules and the 56 Act. The decision of the Speaker recognizing Shinde as the leader is illegal. Now, whereas the Speaker says just the contrary. On the ground that I look at, there is no constitution. I look at the 1999, leadership structure is inconsistent with it. Therefore, I will discard all that. And therefore, we are left with the legislature and he is the political party. Even if you are left with the legislature, he can't be the political party. That's decided by the Constitution Bench. Despite the aforesaid, based on the perverse logic that majority legislators represent the SHIVSENA political party itself, the Speaker decided to recognize Eknath Shinde as the validly appointed leader and Gokavale as the validly appointed whip. Whereas this is, I'll just read it because I don't have to go to the document. I've quoted it here. Once it has been held that the Shinde faction was the real political party, it is no longer possible to accept the proposition that a whip appointed prior to the emergence of the faction previously would continue to hold the power, especially when he did not belong to the real political party. It could be argued that his removal was by a resolution of the legislative party and not by the political party. But this is easily answered when it is understood that the recognition of the Shinde faction as a real political party has resulted in severing the umbilical cord that connected Sunil Prabhu to the real political party. If this were not so, then the legislatures would have no choice but to follow the direction of any whip, which might not reflect the will of the political party, or might even be contrary to the intent or directives issued by the political party. Such a whip could act with impunity against the will of the political party, as well as the legislature party, on the specious assumption that his original appointment was validly made. In view of my finding that the Shinde faction was the real political party when the rival factions emerged, and in view of the resolution of 23rd of June passed by the Shinde faction, I have come to the conclusion that Eknath Shinde was the validly appointed leader of the SHIVSENA political party, contrary to the Constitution Bench. In view of my findings that the Shinde faction was the real political party when the rival factions emerged, and that Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022, I further conclude that Bharat Gogavale was validly appointed, again contrary. It is respectfully submitted that the Speaker's decision is in the teeth of the categorical findings of this bench, the Constitution Bench in Subhash Desai, and liable to be set aside. Then, Maharaj, what are the undisputed facts, Maharaj? Maharaj, I just want to make one thing clear. I am not going to go into any documents provided by me, because questions have been raised about those documents, Maharaj. I am not interested in, Maharaj, trying to prove to your lordship that these are genuine. I will go by the undisputed facts that both sides agreed upon and then make my submission. So what are those undisputed facts? Kindly see, Maharaj, on the left-hand side, the table, 21st of June, 26th of June. Para 35, the following undisputed facts are sufficient in law to attract disqualification. While camped together in same hotel in BJP-ruled state of Gujarat, Surat, on 21st June, respondent MLAs passed a resolution of SHIVSENA legislature party seeking to change the chief whip appointed by the political party and reaffirming Eknath Shinde as their group leader as a direct affront to the political party. Further, they marked a copy of this resolution to the Honorable Governor, who had no role whatsoever in the matter, demonstrating their intent to topple the government. Malas, I want to show this document to your lordships, where they show, Malas, they're a copy to the governor. Kindly have a look at that. That's at page 117, Malas, of the convenience compilation.
117?
117 of the convenience compilation. I just want to show your lordships that resolution. Where to governor?
23.
Work करेंगे.
This is a legislature party resolution.
Yes. Now, Malas, this is undisputed, this document. It's a legislature party resolution. So we go by that. It's their document. That's dated 21st of June. Resolution of the meeting of SHIVSENA, Maharashtra Legislative Assembly. And it's marked to the governor. Then there's signatures below, and it's marked to the governor at page 123. What's the relevance of that? How is a resolution of the legislative party marked to the governor? What role does the governor have to play? Because that's how the governor called for a floor test. And Subhash Desai held that action of the governor to be illegal. So all that the speaker has said is entirely contrary to the findings of the Constitutional Bench. So I just wanted to show this to your lordship, Malas. Yes, now come back, Malas, too. So this is undisputed. These two acts by themselves, they are liable to be disqualified. Then Malas, back at page, at that table, Malas. Page 11, second table. Then the undisputed fact on 22.6. Respondent MLAs refused to attend the meeting of the SHIVSENA Legislative Party on 22.6 on the instructions of the party president by disputing the authority of the chief whip of the political party to issue a notice. Who was the chief whip? Sunil Prabhu. He called for a meeting. They gave a reply. You have no authority to call for the meeting because we have our own whip, namely Gogavale. This is an undisputed fact. That itself, Malas, this is the third fact which makes them liable for disqualification. Then come the next, that is 22.6 onwards. Respondent MLAs traveled from Surat to Guwahati and stayed in the same hotel. It was reported in the news that the logistics of the respondent's stay at the hotel were closely overseen by an MP and 3 BJP ministers close to the Chief Minister of Assam, and BJP Yuva Morcha leaders were seen to be staying in the hotel in turns. Eknath Shinde also released a statement that his group had the backing of a national party. Now, Malas, they may dispute it, but I think enough to ferret out, infer the reality of the situation. They formed the government on the 30th with the BJP. And they traveled to Surat and then to Guwahati. That itself is telling. And you don't have to produce evidence to show that. I think now you know, I know, they know. Now the answer. According to us, this also should be undisputed. Anyway, next. That's why I made no comment there, Malas. Then kindly 28.6. The leader of the opposition, Devendra Fadnavis, met the Honorable Governor and requested him to direct the holding of a floor test. The Honorable Governor then called for a floor test relying on the resolution of 21.6. That's undisputed. That itself will result in disqualification. The next. On 30th June, Eknath Shinde, with the support of the respondent MLAs and the BJP, met the governor and staked his claim to form the government in Maharashtra and was sworn in as chief minister without reference to the political party. Undisputed fact. Then on 3rd of July, respondent MLAs admittedly voted for Rahul Narvekar, the BJP candidate for the speaker's election, despite being another candidate, Shri Rajan Salvi of the SHIVSENA. At that time, there was no question of another political party. Now that's the 2-1B, undisputed fact. The others are 2-1A. This is 2-1B. Then 4th of July, all respondent MLAs admittedly voted in favor of the government formed by SHIVSENA, by Shinde, with the support of the BJP in the confidence vote on 4-7, undisputed, again 2-1B. So it is respectfully submitted that the actions of the respondents resulting in toppling of the MVA government, of which the SHIVSENA political party was a part, and the formation of a new government with the support of the opposition BJP is a classic case of political defection in violation of the 10th schedule. This honorable court has in several decisions held that the mere meeting the governor with the opposition party amounts to violation, but this is held in Rajendra Rana, amounts to violation of para 2-1A. In the present case, the respondents have not only supported the opposition party in toppling the duly elected government formed by their party, but rather they have themselves formed the government with the support of the opposition party. Reference is invited to the decision rendered in Rajendra Singh Rana. Para 48. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to act of voluntarily giving up membership of the party on whose ticket the said members had got elected. Clearly from the conduct of meeting the governor accompanied by the General Secretary of the Samajwadi Party, the party in opposition and the submission of letters requesting the governor to invite the leader of the opposition party to form a government, as against the advice of the chief minister belonging to the original party to dissolve the assembly, an irresistible inference arises that the 13 members have clearly given up their membership of the BSP, no further evidence or inquiry. This is what I'm asking your lordships to infer. No further evidence or inquiry is needed to find that the action comes under paragraph 2-1A. The very giving of the letter to the governor, requesting him to call the leader of the opposition to form a government by them itself would amount to the voluntary giving up of membership of the original party within the meaning of paragraph 2. And then, in Srimat Balasaheb Patil, is another, I think it's three-judge judgment of this court, Karnataka matter, we did it together. Says the speaker in the impugned order has taken note of the surrounding circumstances, including the conduct of the petitioners from February 2019 onwards. It ought to be noted that sufficient opportunity of hearing was accorded to the petitioners herein, who had also filed their responses. It ought to be noted that while notice dated so-and-so, and a meeting of the INC Legislative Party was called on 18/1/19. The notice stated that the members must compulsorily attend the meeting, otherwise action will be taken against them under the 10th schedule. The petitioners did not attend the party meeting on 18/1. Admittedly, the petitioners also refrained from attending the subsequent general body meeting on 16/2, as well as the assembly session. The resignations were submitted by the petitioners nearly 4 months after the disqualification petition had already been filed. Similarly, Malaj, when Sunil Prabhu asked them to attend the meeting, their answer was, you have no authority to. So it clearly falls within this dictum here, Malaj. Then para 38. Notably, while disqualification petition 1 to 16 were filed on 23/6 and disqualification petition 18 was filed on 27/6, the petitioner had filed an additional affidavit on 23/9, bringing on record the subsequent facts, including Eknath Shinde meeting the governor, staking claim to form the government, and taking oath as the chief minister on 36. The respondent MLAs supporting the government formed by Eknath Shinde in the confidence motion on 4-7, and many respondent MLAs serving as ministers in the government led by Eknath Shinde. The filing of the additional affidavit was objected to by the respondents. We filed that and they objected, on the basis that the petitioner was seeking to amend the pleadings and bring in fresh facts. At that time, I didn't know the facts, they only came to be known later. That did not have a bearing on the alleged time and event when the members allegedly incurred disqualification. It was also claimed that the new pleadings would become part of the petition and the respondents will have to be given time to file additional affidavit. After careful consideration of these submissions, the additional affidavit dated 23/9 was categorically taken on record by the speaker, White order dated 2010. The facts mentioned therein thus became part of the pleadings and required consideration. Due to this, these facts subsequent to the filing of the disqualification petition were also considered by the Speaker in the impugned judgment, even though it was eventually held that the facts did not lead to the conclusion that the respondent incurs disqualification. Therefore, my lords, we say it is respectfully submitted that instead of appreciating the legality of the above actions in a holistic manner, the Speaker in the impugned judgments has considered some of the contentions in an isolated manner and held that the same be not established on erroneous technical grounds. The main contentions based on the undisputed acts of the respondents have either not been dealt with or rejected on the ground that the respondents themselves represent the political party. So what does he say, my lords? We said respondents became incommunicado. He says, how can I decide that question? Because we haven't put forth any. The reason was, my lords, that they went to Surat and they went to Guwahati. Where was the question? But anyway, we won't go into that, my lords. As I told your lordships, I am not on our acts. I am on the undisputed facts. Second is respondents remained absent in the SSLP meeting held on such and such. That is because they say Shinde is the real political party, which I have already, my lords, addressed your lordships on. Respondents' deliberate absence. He says they are the political parties, so not relevant. Respondents' resolution purporting to change the whip. They say they are the faction, which is the real political party. Respondents acting in concert with EJP. They say that's a mere allegation. No inference can be drawn. Anti-party, anti-coalition statement. They say newspaper reports. Whereas in these matters, courts have relied upon newspaper reports because you can't lead evidence. Eknath Shinde meeting the governor, he said Shinde faction was the real political party. Therefore, it is respectfully submitted that the undisputed facts on record clearly establish that the respondents are liable to be disqualified under 2(1)A. Then, Millers, under 2(1)B, I've already, Millers, told your lordship the undisputed facts. I won't repeat them, Millers. Then kindly come straight away to paragraph 44. Speaker's reasons for the 2(1)B, Millers. No. Yeah, para 44. Yes, right. This now? Where is para? This? Well, it's just the finding of the Speaker in the second table. Shinde faction was the real, but we've already said all that. We've said all that. Let's not repeat it. Service of whips, we've said all that. Petitioner's group had not complied with. Now, this is important. Item 3, petitioner's group had not complied with the requirement of Rule 3.5 of the Members Maharashtra Legislative Disqualification Rule. Rule 3.5 says that within a certain number of days, you can, condone the act of disqualification. So he says, since you have not said that I don't condone it, therefore I assume that you have condoned it. This is 3.5. That's how the logic is. As your lordship knows, under all these rules, within 20 days or so, if the party writes that he has incurred disqualification, but let's condone it, I don't want you to deal with it. In this case, I did not write. So he says, the fact that I did not write shows that I have condoned. But I filed disqualification for us. So obviously I have not condoned. So this is the logic of the Speaker. Well, it's a very, very flight of his imagination is really very compelling. Whips did not state that item 4, did not state that in case they are not followed, it would result in. Item 4, he says, whips did not state that in case they are not followed, it would result. They say the whip should have stated that in case they don't follow the whip, it will result in disqualification. Since it did, we did not state it, therefore, how can it be disqualified? Then comes to 5. No whip can be issued for election of the Speaker since the candidate was not set up by any political party. when we are the party and they are in the house, whip will be issued. This is our candidate. This is the political party's candidate. This is also completely wrong, Mullahs. Then 6, Gogavale was recognized as the whip on 3/7/2022. Legislators who acted as per this whip cannot be faulted, but we are challenging the very appointment of that whip. This logic is also, Mullahs, something that needs to be. Then what else? That's it. Mullahs, I just want to read 2 paragraphs, Mullahs, in Kyoto. Last document is Kyoto, Mullahs. Which other paragraph? The sin of defection. Sin of defection.
And the judgments compilation,
I'm sorry?
in the compilation,
Yeah, we've given it, Mullahs, just a new one. I'm sorry.
It's not there in this compilation.
I'm
It
sorry.
wasn't there in.
Yes, yes. Which is the paragraph on this sin of disqualification? Sin of disqualification. You can mention it. Para 122, Mullahs. Another one. Yes, yes. Para 140, page 725 of this. No, sorry. It starts at page 86 of this compilation, Mullahs, and at 160, 160, Mullahs. Just add these 2 paragraphs and then I've done, Mullahs.
160.
160 page, paragraph 140 of this judgment.
140 on top.
Yes, top is that. My Lord Justice Mona just Bakshi have that. Kindly see, Mullahs, para 140.
Potentially.
The 10th schedule was inserted in the Constitution by the 52nd Amendment, which came into force with effect from March 1, 1985, and is popularly known as the Anti-Defection Law. The statement of objects and reasons says that this amendment in the Constitution was made to combat the evil of political defection, which has become a matter of national concern, and unless combated, is likely to undermine the very foundations of our democratic system and the principles which sustained it. These are prescient words. So, Mullahs, my submission to your lordships is as a matter of interpretation. Please don't interpret it in the 10th schedule for allowing defections to take place. Because that's a sin. Karnataka judgment says the same. This amendment is therefore for outlawing defection to sustain our democratic principles. The 10th schedule contains 8 paras. Para 1 is the interpretation clause defining house to mean either House of Parliament or the Legislative Assembly, or as the case may be, either house of the legislature of a state. The expression legislature party and original political party, which are used in the remaining paragraphs, are also defined. Para 2 provides for disqualification on ground of defection. Para 3 provides the disqualification on ground of defection is not to apply in case of a split, indicating therein the meaning of split. Para 4 provides the disqualification on grounds of defection is not to apply to a case of merger. Para 5 provides for the Speaker or the Deputy Speaker of the House of the People of the Legislative Assembly of the state, the Deputy Chairman and Council of States, or the Deputy Chairman of the state from the applicability of the provisions of the 10th schedule. And therefore, he says, Mullahs, at the heart of the issue is that the manner in which people violate the 10th schedule, the only defense is available under paragraph 3 and paragraph 4. Otherwise, make sure that you do not destroy the very foundations of our democratic process by encouraging, through an interpretation of the 10th schedule, defections that will take place. So if you say that, look, after 19th of July, he has got that much support, that's encouraging defection. Because when you are in power, this will happen. After 21st of June, this happened. Oh, but that's wholly irrelevant. In other words, my lords, you must freeze the event on the 21st of June and on the 19th of July. Anything that happens thereafter is encouraging defections, not dealing with the sin of defection. That's at the heart of the interpretation of the 10th schedule, my lords. And I pray to your lordships, it's my considered, my lords, opinion, and I plead before your lordships, my lords, to hold that SHIVSENA name belongs to Thackeray, to hold that the faction of Shinde cannot have the symbol. And the fact that they have enjoyed the benefit of that symbol is not a case of equity. It's a case of illegitimate use of a symbol. It should be frozen. If he can't have it, I can't have it, it has to be frozen. And the name belongs to me.
This is your alternate.
This is my alternate submission. You can't, well, he cannot create equity by doing something illegal from the inception. With those words, Mother, I'm deeply obliged. You've been very, very patient with me. I'm honored, Mother, to have argued this matter.
Thank you. Thank you, Mr. Chairman.
I will show it. Let him do also.
But I'll be very brief, my lord. My learned friend has covered most of the topics. Lord, for the first 10-15 minutes, I'll deal with disqualification since your lordships are already hearing it. And balance, my lord, I'll devote to the symbol matter. Lords, I've put all my thoughts on my lord's paper, and I'm not going to read the written submission. Broadly, I'll indicate, my lord, what the points are as far as disqualification is concerned. My lord, obviously the first question, my lord, which I hand it over. Lord, which will be relevant is, why are we discussing the disqualification? Because the period is already over. And my lord, my learned senior colleague already hinted that, my lord, pursuant to a constitution bench judgment in Rana, and my lords, followed by a 3-judge bench in Srimant Patil, your lordship's court have already taken a view that, my lord, the final verdict regarding disqualification is only an ex post facto recognition of the fact of disqualification which has happened. Now here, my lord, the acts alleged have happened between 21st of June till 4th of July. So if your lordships are pleased to hold in our favor, then, my lord, the declaration would go back. So that's the first point, my lord, and I have, my lord, extracted the relevant submission, observations of the court. If your lordships are pleased to have, my lord, page 2 of my note. You've given the disqualification. Yes. Page 2 of my note, my lord. Submission A, the outcome of the present petition has a direct bearing on the symbol dispute. And, my lord, the relevant portion of the judgment in Srimant Patil, my lords, I'll just place that. Lords, that is in paragraph 6. In addition to the above, the decision of the speaker that a member is disqualified relates back to the date of disqualifying action complained of. The power of the speaker to decide upon a disqualification petition was dealt by a constitution bench in Rana. This court, reading the provisions of paragraph 2 and 6, has clearly held that the speaker has to decide the question of disqualification with reference to the date on which it has occurred. So this is the relevance part.
But can we declare him to be disqualified today?
Yes, my lord.
The speaker having not declared him disqualified erroneously or otherwise?
Yes, my lord. My lord, the submission would be this.
Because we are not an appellate body.
Yes, my lord. But ultimately,
exercising judicial.
Correct, my lord. Ultimately, my lord.
Decide quash an order.
Yes, my lord.
Order is illegal.
Yes, my lord.
But can we assume the role of the speaker and disqualify?
My lord, ultimately, my lord, the list was alive when we, my lord, filed the SLPs. And, my lord, the judicial review in...
Here
yes.
in what I
yes, yes.
If an order is challenged in judicial review,
yes,
and the order is found to be perverse,
correct,
illegal, we can set aside the
yes,
order and remand the matter for fresh consideration in terms of the direction.
Your lordships have also said, my lord, in disqualification matter.
Correct. But can we assume the role of the speaker
lords,
and say that he is disqualified and would be deemed.
My lord, in all these cases, my lord, where disqualification, my lord, was ruled out by the speaker, when the matter came up in appeal, your lordships decided it and said, my lord, that he is disqualified. Lord, your lordships exercised power, my lord, of judicial review. And in 110, 111 of Kyoto, your lordship said that, my lord, judicial review is limited against the order of a speaker. If the order of the speaker is perverse, which we will demonstrate.
Restrictive role of
Yes.
a cassation court,
Yes, my lord.
unlike an appellate court,
Yes, my lord.
is to assume the jurisdiction of the court
Correct,
of
my lord.
justice.
Correct. But
So,
so therefore, my lord, the speaker's order, my lord, emanates as is, my lord, it's not, my lord, in the capacity of the, my lord, leader of the house. My lord, it is a tribunal. So therefore, my lord, when the tribunal has acted with perversity, I'll cite that paragraph, my lord, that your lordships will correct it in judicial review. If the speaker has failed in his
that order.
duty, my lord,
You-
and your lordships can also give the relief.
That is what we say.
Yes, my lord.
That we have no doubt in our mind
Yes, my lord.
that if the approach of the speaker is contrary to law, and
Correct, ma'am.
Mr. Sibal has argued before us
Yes.
very eloquently that Subhash Desai principles were
Correct,
not
ma'am.
considered or considered incorrectly. We are with him, we set aside.
Yes, ma'am.
But can we say that consequentially we declare him disqualified?
My lord, the reason will be that, my lord, although the effective relief will not be there, because, my lord, under 194, my lord, the term of the assembly, my lord, is what is relevant. My lord, it will be a disqualification, a declaration will be given, my lord, but with no consequent relief.
No
Lord,
consequent relief.
Lord, even in, my lord, 356 matters, your lordships are aware. SR Bommai, my lords, was decided much after the, my lord, yes, my lord.
It's a much limited
Correct, my lord.
area.
But the declarations were given, but in view of the fact, my lord, that assembly elections were held. Yes, I'm
In
sorry.
fact, 356 is not even a comparable.
Correct, my lord. It's much higher, my lord. It's much
Much
higher.
higher.
Much higher. So this is, we are dealing with the tribunal's order, my lord.
Constitutional power
Yeah.
exercise, very limited area.
Correct, my lord.
Speaker is exercising quasi-judicial power.
I'm grateful, my lord.
Doubt
Grateful.
in our mind,
Correct.
and we have also known hesitation
Yes.
to issue a writ of certiorari.
Yes, my lord.
The question is, can we issue a writ of mandamus and say that he shall be deemed to have been declared?
My lord,
this
once the declaration is given, my lord, your lordships will also clarify. I'm sorry.
mandatory order can be given.
My lord, I am
Because
on
in
this.
doing that,
Yes.
we would convert ourselves from a court of review to a court of appeal from the order of the Speaker,
My lord, in
which the
all these-
Constitution did not provide to us.
My lord, in all these judgments, where your lordships have upheld disqualifications, where the speaker, my lords, had refused to adjudicate on disqualification, your lordships have disqualified them. Exercising, I'll make a chart, my lord, and give it, my lord, so that, my lord, my lord, as far as that is concerned, my lord, we'll give judgments and the paragraph number.
Just wanted
Yes,
to
but
check
including-
because of
yes.
this unique factual situation.
Yes, my lord. But ultimately, my lord, if your lordships have the power to give a declaration, the fact that the term of the assembly is over.
Doubts.
Yes, my lord. So that,
There is no doubt
Yes,
in
ma'am.
that we can caution and set aside the
Correct,
order, dismissing the
Yes, ma'am.
disqualification.
Correct.
And say that it was incorrectly decided,
Decided.
wrong parameters,
Yes,
etc.,
ma'am.
etc.
Now, my lords,
Can we, the next thing is what?
On the
Yes.
resultant,
Yes.
my lord, the reason why I'm saying, my lord, even if your lordships are pleased to hold, my lord, that the,
Let's consider a situation,
Yes.
again, not very comparable.
yes, ma'am.
In a disciplinary proceeding,
Yes.
someone is given disproportionate punishment. We can cost the punishment. Can we impose the punishment? We have to remand it again, consider, ask the disciplinary authority to pass appropriate order
Yes, ma'am.
in accordance with the direction.
Yes, ma'am. But
Scope, having gone because of the expiration of the tenure, whether we can declare him.
my lord, even if, my lord, I bow down, my lord, to what is falling from your lordships, if your lordships are pleased to hold that, my lord, the disqualification petitions were incorrectly decided, my lord, let's assume that, then, my lords, it will have a definite bearing, my lord, on, my lords, the symbol dispute. Because in Subhash Desai, my lord, this very conundrum, my lord, which there are two parallel proceedings, my lords, one disqualification, one ECI. Will the ECI, my lord, be justified in applying the test of legislative majority. My lord, the Supreme Court in Subhash Desai said they will not be justified. So therefore, my lord, yes, my lord. So therefore, even if your lordships are pleased to hold that the order is illegal, my lord, it will have a definitive impact on the symbol dispute. That's all I wish to say.
Kamath,
Yes, my lord.
there is no dispute that Mr. Shinde had legislative majority.
Correct, my lord. Correct.
But the question is, when he assumed legislative majority,
Yes.
did he remain the party?
Correct, my lord.
Remain the party.
Correct, my lord. Lord, as far as the disqualification is concerned, Lord, that question will be entirely irrelevant. Now, my lord, there are a few principles, my lord, in Subhash Desai which really answer this. My lord, those paragraphs I don't wish to point out, but please have a look at, my lord, I've made, my lord, a chart of what the principles are and with references to the paragraph numbers. I have placed it under 4 headings, my lord, in paragraph 8. If your lordships are pleased to have paragraph 8, my lords, at page 3. Not the first principle my learned senior colleague has already dealt with, that the political party and legislature party are 2 different concepts. But one thing, my lord, if your lordships are pleased to turn to page 4, principle G, a legislature party cannot set up a candidate. Your lordships got that, my lord? That is, my lord, in 116.1, in page 4 of my note, my lord, in paragraph G, on top, my lord. Page 4, my lord. Lordships got that. Now, my lords, this is relevant because, my lord, the Constitution 10th schedule, by a deeming fiction, my lords, in the explanation, clearly states who is the original political party. And that is, my lord, whichever party, my lord, has set that candidate as far as the election is concerned. So Subhash Desai is very clear that a legislature party cannot set up a candidate for election. If that be the scope, my lord, then the inquiry as to, my lords, whether the legislative majority can constitute the political party is entirely beyond the ambit of the 10th schedule, my lord. So that is point number 1. Then, my lords, kindly turn to the second set of principles. The purpose of symbols order and the effect of the decision under paragraph 15. Now, my lords, if your lordships are pleased to see C in this, item C, the substance of the decision under paragraph 15 is which of the groups is the lifeblood of the political party. Now, this is very important, my lord, because your lordship's court felt that in paragraph 15, my lord, the essence of the dispute is to find out who really is the lifeblood of the political party. In that sense, my lord, that lifeblood is recognition of de facto state of affairs. So, my lord, the inquiry as to whether, my lord, the constitution is de jure, whether your conduct is de jure, etc., that can't be the test at all. Subhash Desai said you have to find out the lifeblood, who are in majority, who constitute the heart and soul of the party. That's one of the principles. Now, kindly see, my lord, the heading 3. My lord, this is what I was, my lord, attempting to submit. The potential for complications where there are simultaneous proceedings of paragraph 15 and the 10th schedule. Now, this is a heading in Subhash Desai, and the relevant paragraphs, my lord, I have cited. Scenario A, ECI gives its decision first, which has happened in our case. Scenario B, Speaker gives its decision first, which has not happened. Now, kindly see, my lord, the next. If the faction which enjoys the majority in the House is disqualified after being adjudicated to be the political party, the very foundation of their claim, being the political party, no longer subsists. This is not a constitutionally desired outcome. So therefore, in our case, my lord, where the disqualification has happened after the ECI, and, my lords, if your lordships are pleased to then hold that, my lord, this disqualification order is not correct, then the reliance by the ECI on the legislative majority, Supreme Court says it's not a constitutionally desired outcome. Then, my lords, D is extremely important. And where, my lord, the Election Commission has gone completely wrong. And this paragraph, my lord, is paragraph 157, 158. In such circumstances, it would be futile to assess the legislative majority in paragraph 15 and the ECI should look at other tests. So therefore, my lord, the entire foundation, as your lordships have seen, my lord, from that 101, etc., in the Election Commission's order, entirely goes, because Supreme Court says you cannot have legislative majority test when there are parallel disqualification proceedings. Then, my lords, kindly see E. The decision of the speaker and the decision of the ECI are based on different considerations and are taken for different purposes. Your lordship saw yesterday, my lord, that the speaker cites, my lord, sadically and says, I will find out who is the party depending on legislative majority. Supreme Court says the tests are completely different. Then, my lords, F, the decision of ECI has a prospective effect. Lord, this is very thoughtfully, my lords, worded. My lord, the Supreme Court was conscious of the, my lord, difference in the nature, genre of proceedings as far as, my lord, the 10th schedule is concerned and the ECI, as your lordship, my lord, Justice Bagchi has been putting to us. My lord, the ECI proceedings under paragraph 15, my lord, is a proceeding of adjudication as to which of the rival factions constitutes the lifeblood of the political party. And, my lords, pursuant to that determination, the political leadership of that party can change. So, my lord, the status quo can be altered in a paragraph 15 proceedings. But as far as, my lord, 10th schedule is concerned, it is only identification, my lord, of who's the political party at the relevant time. So there is a complete, my lord, difference, jurisprudential difference between paragraph 15 and, my lords, paragraph and 10th schedule. Then, my lords, the fourth heading. What are the principles which govern adjudication under the 10th schedule? This is Subhash Desai again. In cases where a petition is filed after the commission of prohibitory conduct, which is the 21A and 21B, the decision of the ECI cannot be relied upon by the speaker for adjudication of the disqualification proceedings. Then, my lords, if the petitions are adjudicated based on the decisions of the ECI, in such cases, the decision of the ECI would have a retrospective effect, which is contrary to law. Then, my lord, C is also extremely important. And, my lord, this I am going to devote a little bit of time. My lord, Supreme Court says when the prohibited conduct is committed under the 10th schedule, there is only one political party. And the speaker has only to determine prima facie who the party was at the time when the prohibited conduct is committed. So, my lord, that prima facie determination is not adjudication. The speaker here, your lordships have seen, has gone on, my lords, adjudicating whether the 2018 leadership structure is valid, invalid, whether it is in conformity with the 99 Constitution. Prima facie determination would only mean, my lord, that under explanation explanation question of an adjudication. Therefore, my lord, there is a complete jurisprudential difference, and he has conflated, my lord, the paragraph 15 adjudication and brought it under, my lord's 10th schedule. Then, my lords, kindly see D. No faction or group can argue that they constitute the original political party as a defense. Now, this is very important. This is paragraph, my lord, 170. If, my lord, a legislature facing disqualification can have the defense that no, I constitute the political party, then all this, my lord, evidence comparing whether, my lord, the 2018 Constitution is on record, 99 Constitution, whether the leadership structure matches. But the Supreme Court says that in paragraph 170, I can place that, my lord, just want me to place that. Paragraph 170, my lord, between placitum D and E. Page 90, my lord. The question before this court is, what is the impact of deletion? I'm sorry. In Mr. Sibal's compilation, it's page 90. My lord. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both factions of the SHIVSENA, claiming to be the real SHIVSENA. In effect, this points to the existence of a split within the SHIVSENA legislature party. However, no faction or group can argue that they constitute the original political party as a defense against disqualification. And then the court says, my lord, in paragraph 174 and 175, that the speaker has to do only a prima facie determination. And this, my lord, my learned friend has argued yesterday, this is in a case where both parties, my lord, have tried to amend the constitution, have placed different versions of the constitution before the ECI. There are different leadership structures. Then the question will be, who's the political party? That question doesn't arise in our case. Then, my lords, kindly turn to, my lords, E, which is again a prima facie determination. Supreme Court has said in, my lord, 3 places. I've given the paragraph numbers. Then, my lords, F is that portion of 175, where if rival groups submit 2 or more versions of the constitution, the speaker must consider the version of the constitution which was submitted to the ECI. That question doesn't arise here. Then, my lords, G is extremely, yes. Yes.
170 has to be read with 174.
Yes, my lord, correct.
174 says.
Yes.
See the last.
Yes, my lord. The determination is a.
Determine which of the members of the parties are voluntarily given up membership.
Yes, my lord.
It is necessary
Correct,
to
my lord.
determine which of the factions constitute
Correct.
the political.
Correct, my lord. I was making, my lord, a nuanced point.
So when you see 170,
Correct, my lord.
you read 174.
Correct, my lord.
Together. 170 is in relation to split.
It also says there is no defense.
Why? Because
Yes, my lord.
split is no longer a defense.
Correct, my lord.
So who is the original political party?
Correct, my lord.
Who are the membership
Yes.
in legislative party?
Yes.
Does not matter.
Yes.
Because you cannot have a split as a defense.
That's right.
But when paragraph 2 is to be determined of voluntary given up of membership, then which group you claim or you allege to have voluntarily given up membership, whether they are the party, is something which
That is. That's the submission which I was making, my lord. That's the my lord nuanced point which I was making.
You said that C is not correct. Prima facie, it has to.
Yes, my lord. But a defense, my lord, can go beyond prima facie. Lord, defense can be that I have to adjudicate, Lord, the entirety, whether the 2018 constitution is on record, etc. But in a prima facie determination, my lord, this is beyond, my lord, the scope of the speaker's jurisdiction. That's the point, my lord, which I was making. Then, my lords, G is extremely relevant. 40 हो गए. Then, my lords, kindly turn to G. Speaker, this is, my lord, very categorical. Speaker must not base his decision on legislative majority alone and the structure of leadership.
That 175 paragraph is a very interesting paragraph.
That's true, my lord.
First 10 lines for Mr. Call. Last 4 lines for you.
Paragraph also. The last submission. You have a similar para in your submissions also.
That paragraph will require
Lord, according to us,
deeper scrutiny.
Yeah.
You need whole general clause reject.
Says rival rival constitutions have to
Yes,
be
my lord.
considered.
But in our case, my lord, there were no rival constitutions. Yes,
In what context was
Yes,
Bench
that's true.
saying rival constitution?
yes, ma'am. No, it was an abstract, probably position of law, my lord, may not be relevant to the facts.
Even abstract.
That is what we say, paragraph 125, 175. Very,
Yes, my lord.
we have to be very careful in
Yes,
reading 175. Last 5 lines are very clear.
yes, ma'am.
That legislative majority
Cannot be looked at. And
cannot be given that importance.
primacy, my lord, primacy. Now, my lords, another sub facet of this, but what was argued, my lord, in detail before the speaker was that, my lord, a speaker's proceeding is like a civil trial. And, my lords, I have to, my lord, put my case, my lords, beyond reasonable doubt, etc., as a quasi-criminal trial, etc. But that is now well settled, my lord, that there is no list, so to say, between me and, my lords, the respondent legislators. It is the duty of the speaker to find out if prohibited conduct under 10th schedule has happened.
So it's more inquisitive.
Yes, my lord, if your lordship sees that I have dealt with, my lord, in paragraph 10, if your lordships are pleased to see the judgment in Mahachandra Prasad, it's a 3-judge bench. And I've quoted the relevant portion. The judgment is there in the latest compilation. The highlighted portion, my lord, there is no list between the person moving the petition and the member of the house who's alleged to have incurred a disqualification. It is not adversarial. Even if he withdraws the petition, it will make no difference, as a duty is cast upon the chairman or the speaker.
That comment is
Yes, ma'am.
in the context of that.
Of the 10th schedule. Yes.
The context of that. It's something
Correct.
like a partition suit
Yes, ma'am.
or a public interest.
Yes, ma'am. Correct.
That if the
Election
party who has initiated it
Yes.
loses interest, still
The speaker will carry it.
subsist
Correct.
constitutional duty for the speaker to decide.
Lord, in fact, in Sharad Yadav's case, my
Because
lord,
you never know.
yes,
See, the beauty and the uniqueness of politics is beyond rational
that's right.
extension of possibilities.
Correct.
Because a person who moves the disqualification tomorrow may join the disqualifier.
That's true, my lord.
What happens then?
That's
Election
true.
appeals also, if the third parties do cut.
Correct, my lord.
That's why.
Also, my lord, in several cases,
I hope it is.
my lord, which have been upheld by this court, the speaker did not rely upon, my lord, the evidence adduced by the parties. He said, I have seen on TV.
On his own.
On his own. So that is, my lord, the duty of the speaker, because ultimately, as my lord, it was pointed out that the constitutional sin of defection, my lord, is something which, my lord, goes to the heart of our, my lord, democracy and the functioning of political parties. And speaker, my lord, being the custodian of the house, my lord, as a tribunal, he has a duty. That's, my lord, the point which I was making. Then, my lords, the other point in paragraph 12, which I have tried to address is, now, my lord, when the first set of petitions were filed on 21st, on the 23rd of June, and, my lords, on 27th of June, under para 21A, my lord, the factum of the government formation, which happened on the 30th, the vote of confidence and the speaker's election had not happened. So, my lord, we filed an additional affidavit. And that additional affidavit was objected to. And, my lord, speaker, by a reasoned order, which, my lord, is there in my learned friend's submissions, which was handed over. It's a part of that, page 19. My lord, granted an opportunity to the other side, took it on record, granted an opportunity to the other side to file a reply. And then, my lords, it was taken on record. Now, my lords, one of the questions which fell from the court was that whether the speaker can look at subsequent conduct after the filing of the disqualification, if it amounts to, my lord, a prohibited conduct. And the answer is yes. My lord, I have given 2 instances. If your lordships are pleased to see, my lord, Srimant Patil, my lord, here, paragraph 12. Paragraph 12, my lord. Some of the events the speaker took note of after the, my lord, disqualification petition had been filed. and speaker disqualified them. That was upheld. Not that I have cited in paragraph 12. Then, my lords, one more judgment, which, my lord, fell from the Honorable Court was Sharad Yadav's judgment. And Sharad Yadav, that I have dealt with in paragraph 13, my lord, of my note. My lord, Sharad Yadav's case was a case where, my lord, after the disqualification order was passed by the speaker, Sharad Yadav joined a different political party. Question was whether in judicial review, my lord, whether that fact was a relevant fact or not. So really, my lord, that doesn't apply to our case because all this is prior to the speaker's order. But there are certain important observations, my lord, in that order which actually completely support us. If your lordships are pleased to see paragraph 13, the quoted part, and any event or conduct of a person, even though subsequent to the passing of an order of the speaker or chairman, ordinarily may not be relevant for determining the validity of the order of the speaker or chairman. But in a case where subsequent event or conduct of the member is relevant with the state of affairs as pertaining to the time when the member has incurred disqualification, that subsequent event can be taken into consideration by the High Court. So and so has made very pertinent observation with regard to acceptance of evidence. If the court requires an evidence that can always be received, it was held that all procedure, etc. But ultimately, for the purpose of granting relief, if the subsequent evidence is relevant, my lord, then the court will not shut out that evidence, is what the law is. And that is followed, my lord, in this 1975 judgment as well, which I have quoted. Now, my lords, one important thing, my lord, your lordship saw 175, that it is prima facie determination. And my lords, what is prima facie, my lord? We all know, my lord, I have cited that there is no deeper examination. You can't lead evidence. Prima facie, my lord, when the speaker is required to decide, he has to only go by what is there on the record of the ECI. And if on the record of the ECI, my lord, the political party structure is there, there is no question of going behind, my lord, that party structure under a prima facie determination. Now, my lords, there is a very important thing which I have, my lord, pointed out in paragraph 27, which really, my lord, goes to the heart of this case. And it is this. Now, my lord, I was appointed as the president, elected as the president in 2013. We contested, my lord, the 2014 Lok Sabha elections under my leadership. We had MPs. We had assembly elections in 2014, which were contested under my leadership. Then, my lord, several elections were fought between 2014 and 2018. In 2018, my lord, the fresh organizational election where I'm again elected. And in 2019, my lord, leadership, under my leadership, elections were fought for the assembly and, my lords, the Lok Sabha. And, my lord, Mr. Eknath Shinde was elected on the symbol which was given by my party leadership. In 2022, my lord, one fine day on 21st of June, he decides to, my lord, move across the aisle and, my lord, join a different political party. And in doing so, my lord, he says, I am the political party. And the real constitutional question is that, my lord, when there is a political party, there is a leader and he has deputies. The deputy, my lord, sometimes is not happy. Question is whether he can straight away jump the aisle, commit prohibited conduct and say then that I am the political party, or is it constitutional, proper resort to change the structure of the leadership of the party. And, my lords, if that fails, he has paragraph 15, where he can effect the change in leadership. My lords, going and making, being a chief minister, my lord, is not so important compared to, my lords, the fact that if you are asserting political leadership, then you have to do it, my lord, first intra-party through the statutory mechanism of paragraph 15. And if you choose to, my lord, bypass this, then, my lords, the hammer has to fall under, my lords, paragraph 10 schedule. That's the submission, my lord, which I have tried to canvass in my lord's paragraph 27. It is submitted that a harmonious reading of the provisions of the 10th schedule and paragraph 15 of the symbols order clearly outline the timelines procedure for any legislature who is dissatisfied with the existing party leadership and claims to represent the party to avoid losing his seat in the House. Any such legislature or group of legislature who claim to represent the original political party have to first establish and validate their claim in accordance with law before committing prohibited conduct. The course of action available to such faction includes calling for intra-party convention and effect a change in leadership by a majority support in the party. Arjun Singh says so, that before coming even to paragraph 15, you have to first sort out within yourself. And if I as the leader may not stop it, then you have a right to go under paragraph 15. If the faction in power opposes and precludes any action being taken by the rival group to assert its rights under A, the rival group can approach the civil court or the ECI for effecting a change in status quo of leadership. It is only after the leadership changes and is effected through a legal process, the rival faction can take political decisions. Question is, my lord, without effecting a change in the party structure, can you take political decisions, which is prohibited conduct? The entire purpose of the 10th schedule, my lord, governs political conduct. What is correct political conduct? What is wrong political conduct? And that political conduct has reference to the political party. If you want to change the leadership of that political party and you want to claim that you want to represent that political party, then don't do the political prohibited conduct before effecting such change. And that is, my lord, something which your lordships may have to lay down. That, my lord, unless and until your claim as the party is established in accordance with law, committing this and then claiming in a para that in a 10th schedule proceeding that you are the political party, completely, my lord, puts the 10th schedule, my lord, inversely, upside down, and which cannot be countenanced. And then, my lords, yes. Then, my lord, the next point, which, my lord, I briefly is C4, that there is a jurisprudential difference, my lord, between the 10th schedule and paragraph 15, which I have said, my lord, in paragraph 32. It is submitted that the process of adjudicating of a symbol dispute under paragraph 15 of the symbol order, the Election Commission has been empowered to confer upon a new status of being the political party. On the other hand, the prima facie determination of who the political party is under the 10th schedule is only an identification of the existing status at the time of defection. That is why, my lord, prima facie determination as to who is the political leadership. Then, my lords, as far as the perverse conclusions are concerned, my lord, Mr. Sibal has already pointed out, but just a few things on the 2018 Constitution, which is very interesting, my lord, in paragraph 38. I just want to point out, my lord, some of this already been cited. Now, my lords, in serial number 4 of this, if your lordships are pleased to see, all the legislators, my lord, in the disqualification petitions filed the 2018 Constitution clearly, my lord. Then, my lords, in evidence, we asked one of the legislator a question that, my lord, is at page 15, one Mr. Dilip Lande. Witness is shown the index of his reply as well as annexure R1 to R18. Please refer to annexure R18, which is the 2018 Constitution. In paragraph 2 of your affidavit, you state that you abide by the principles as enshrined in the SHIVSENA Constitution. Are you referring to the SHIVSENA Constitution annexed to your reply? He says yes, as submitted. Now, my lord, interestingly, kindly note the date, my lord, which is 7th of December. This is his cross-examination. Now, my lords, what happens on the 8th is another witness comes, my lords, on the 8th, which is, my lord, in paragraph 6, which is very interesting. And, my lords, this witness, before his cross, my lord, he says, kindly turn, my lord, I'll read that. It is submitted statement of Yogesh Kadam on 8th of December that filing of the 2018 amended Constitution was a mistake of the lawyer, is a complete afterthought. in the chief, my lord, after the affidavits were filed, a question is asked, obviously to get over 7th of December. The respondent Yogesh Kadam filed his replies to the disqualification in August 22. On 25th October, Yogesh Kadam filed an additional reply containing detailed amendments to 2018 Constitution as well as the 99 Party Constitution. On 25th November, he filed his evidence but did not state anything relating to the 2018 amended Constitution. The statement that annexure R18 was a mistake of the lawyer made by Yogesh Kadam on the very next day, 8 December, after the admission of Dilip Lande regarding annexure of R18. The fact that the witness made a statement even prior to the commencement of the examination in chief is recorded, my lord. Questions were not asked. He said, I made a mistake. I want to come and clarify. So obviously, my lord, it was all, my lord, reliance was thoroughly placed both in the Election Commission, Supreme Court, and in the Speaker. But to take advantage of that 174, 175, my lord, somehow this concept of 2018 Lord Constitution was it. Then, my lords, the next heading only I'll read. Having accepted the relevant organizational structure, that is the 2018 structure, Speaker could not have, my lord, done an adjudication on that. Then, my lords, D3, the legislative majority in 133, 132, 144 is in the teeth of Subhash Desai. Then, my lords, D5, at page, my lord, 18, admittedly, no case of leadership structure by the respondents was set out outside the Legislative Assembly. And Subhash Desai is categorical, my lord, that you can't base your claim even under a prima facie determination to being the legislative party only on legislative majority. You have to show a structure outside the legislative, my lord, party, which was not done, which I have explained, my lord, in D5. Then, my lord, there is no dispute that I enjoyed clear majority in the leadership structure, my lord. That is in D6. I have given the details of the affidavits where, my lord, which were in our support, and the evidence as well in paragraph 66, my lord. So in our respectful submission, my lord, and then lastly, as far as the acts which constitute disqualification are concerned, my lord, these are admitted acts, as my learned friend pointed. More importantly, my lord, the fact that Mr. Shinde became a chief minister contrary to the wishes of the original political party. This is something, my lord, which does not require evidence. This is Lord, this is all in public domain. We filed an additional affidavit, my lord, on this, which I just alluded to. And the speaker, my lord, in the order says, I will not comment on the affidavit because I have held the Shinde faction to be the original political party. So, my lord, the facts are admitted that, my lord, these acts constitute disqualification. The only dispute was, my lord, whether who is the political party. And in my respectful submission, my lord, that inquiry on the validity of the structure of, my lord, the political party was an impermissible inquiry. At the most, my lord, what the Supreme Court said in 174, 175, do a prima facie determination. That is only seeing the records of the ECI. My lord, the speaker has no jurisdiction to change the record of the ECI, my lord, which is reflected on his website even today. The 2018 leadership structure is even today. Now, these are my broad submissions, my lord, as far as the, my lord, disqualification is concerned. But I have a few submissions left on the symbol dispute. My lord, just give me some time tomorrow. I can finish.
No.
Half an hour, my lord.
Well,
Yes, my lord. Grateful for a patient here.
Submissions, Mullahs. Para 13, Mullahs. Small, Mullahs, the thin paper portion. Thin one, Mullahs.
232.
Yes, that's the one. My submissions, yes. Filed on 13th of August. And what has it? This is page 5, Malad. Submission 13.